really fun weekend for us. I hope it was a fun weekend for you and to the competitors as well. Today, the problem is Vandalia Environmental Alliance versus Blue Sky Hydrogen Enterprises. Blue Sky Hydrogen Enterprises is a regional energy company with a successful and profitable waste-to-hydrogen project called Skyloop, which is located in a rural portion of the town of Mammoth, Vandalia. Many community members encouraged Blue Sky to come to town and build Skyloop, as it was the solution to the town's growing waste problem without need for a new landfill. Skyloop has secured all the permits it needs to operate, including the Title V Clean Air permit from Vandalia. However, since Blue Sky began its operations, the Mammoth water supply has elevated levels of PFOA, a forever chemical that the EPA has said has no safe level of exposure. The Vandalia Environmental Alliance, VEA, an environmental group, discovered this PFOA contamination both in the town's water supply and on its educational farm located just 1.5 miles away from Skyloop, where it grows produce for local food banks and educates its members on how to grow their own food. Though through FOIA requests, the VEA learned that Blue Sky's air emissions from Skyloop contain PFOA and are to blame for this widespread contamination. To hold Blue Sky accountable, VEA filed a lawsuit against Blue Sky under RCRA, imminent and substantial endangerment and public nuisance theories. Soon after filing this lawsuit, VEA moved for a preliminary injunction to stop the PFOA air emissions before further contamination occurred. After an evidentiary hearing, the district court granted VEA's motion for a preliminary injunction. Blue Sky immediately appealed the court's order to the 12th Circuit and then moved the district court to stay its proceedings pending appeal. The court determined that a mandatory stay was appropriate, which VEA cross-appealed. On appeal, the parties must wrestle the following issues: whether the district court correctly stayed its proceedings pending the appeal of the preliminary injunction under Coinbase Inc. versus Bielski, whether the VEA has a special injury sufficient to give it standing to bring its public nuisance claim for Blue Sky's PFOA air emissions, whether Blue Sky's air emissions of PFOA is considered disposal under RCRA, and thus the district court correctly determined that the VEA was likely to succeed on the merits of its RCRA ISE claim. And finally, whether the irreparable harm prong of the winter test considers only harm to the plaintiff, or whether harm to the public can also be evidence of irreparable harm sufficient to issue a preliminary injunction. So those are the issues that the court is going to hear today, and I'll pass it off to Fred Martin, who is our competition chair, to introduce the competitors and the judges.
All right, so we have Jessica Smith and Isabel Wilcox from the University of Virginia School of Law. And then over here, we have Rachel Benke and Kiera Figgins from the Texas Tech University School of Law. And then now I will introduce the two judges. We have the Honorable Frank W. Volk. He's the Chief Judge for the United States District Court for the Southern District of West Virginia. We have the Honorable Michael J. Alloy, who is the Magistrate Judge from the United States District Court for the Northern District of West Virginia. We at the school are very appreciative and love that these two judges were able to come and provide their time and come here and assist and judge. So we appreciate it.
Having business before this honorable court are admonished to draw near, and your position to the court is now sitting. The case of Vandalia Environmental Alliance versus Blue Sky Hydrogen Enterprises will now be heard.
Please be seated. My colleague Judge Alloy and I are very grateful to have the opportunity to be here today, and we look forward to the arguments. And I'll go ahead and call the case, Vandalia Environmental Alliance versus Blue Sky Hydrogen Enterprises. We'll hear from the appellant. How do you wish to divide your time?
Your Honor, we would each like to hold 13 and a half minutes for argument with a 3-minute rebuttal.
Thank you.
Thank you.
Please proceed.
Good afternoon, Your Honors, and may it please the Court. My name is Isabel Wilcox, and I, along with my co-counsel, Jessica Smith, represent the Vandalia Environmental Alliance in today's proceedings, or the VEA. Your Honors, this is a case about halting an inept corporation from causing even more irreversible environmental harm. Today, I will discuss 2 main issues. First, the district court's compulsory stay was inappropriate because the 4-factor test established in the Supreme Court precedent Neckin v. Holder should have been applied over the Coinbase v. Bielski decision. And second, the district court correctly found that the VEA has suffered a special injury as required to bring a private suit in public nuisance under the Second Restatement of Torts. I'd first like to talk a little bit about Coinbase v. Bielski, the Supreme Court precedent at issue in today's case. Coinbase was a decision made regarding the Griggs principle, and the issue on appeal there was arbitration. In that case, the issue on appeal was whether or not the district court could even hear the case to begin with.
But this was a district court who felt compelled to make a decision that the court was bound by Coinbase and had no choice. So you're wanting us to disagree with the district judge on that?
Yes, Your Honor. We're asking that you find that Coinbase is not the appropriate precedent in this instance, but instead Neckin v. Holder is. And the real reason behind that is because Coinbase establishes this precedent through a very narrow focus, the focus of questions of arbitration. And we do see that focus grow slightly in the Martinsville v. Express case, Fourth Circuit case. And in that instance, we see that the Fourth Circuit has expanded this narrow interpretation away from solely arbitration, but to all questions of forum authority.
What do you believe the district court should have done?
Your Honor, I believe the district court should have evaluated all 4 factors underneath the Neckin v. Holder, which are very similar to that they evaluated for the preliminary injunction. And the district court, within the record, even stated that if they had the discretion that the court awards them, they would not have stayed proceedings at the district court level. We want to reinstate that judicial discretion that the judge wished that they had at the district court level. And really, these 2 Supreme Court precedents that we're evaluating today afford for that. Both instances, Coinbase as well as Martinsville v. Express Scripts, really limit this automatic stay to issues of forum authority, whether or not a case can even be heard at the district court level. But, Your Honors, in today's case, we're dealing with an entirely different issue, a preliminary injunction. Here, we're not asking the court to decide whether or not the district court can even hear the case.
Well, it's clear they can hear, right?
Yes.
I mean, they have threshold jurisdiction, and that's different than Coinbase, right?
Yes, Your Honor.
Right. That's arbitration, and the Fourth Circuit was talking about where they didn't believe that the court had jurisdiction, and it really should have been state jurisdiction.
Yes, Your Honor.
I
Yes, Your Honor.
expect your opponent's going to suggest that if things proceed apace in the district court, that it's going to terminate the case entirely. How do you react to that?
Your Honor, the issue here on the stay appeal is the issue of the preliminary injunction, and so that is our main focus here. And whether or not the preliminary injunction is upheld does not impact the fact that a trial needs to move forward at the district level. The preliminary injunction is just that, it's preliminary.
But the injunction really wanted to shut them down, right?
Yes, Your Honor.
And to shut them down for how long, and what sort of damage, irreparable, would it cause to Blue Sky?
Your Honor,
You're talking about months, right? This isn't going to be resolved in a day.
yes, Your Honor, we are talking about months.
So these are members of Mammoth who will not have their jobs, will have pollutants sitting elsewhere that they can't process. I mean, how do we figure this out?
Yes, Your Honor, and what the district court really emphasized was this difference between irreparable harm and compensable harm. In this instance, the injuries suffered by the citizens of Mammoth and by the VEA are irreparable. The PFOA emissions in the soil and in the drinking water are forever chemicals. They cannot degrade, and when they enter your bloodstream, they are there forever. And the EPA has shown that this is cancerous. It can lead to cancer, birth defects, developmental delays. And this is currently blanketing the community of Mammoth.
Well, what do you think about the argument that it's really compensable and that they're getting bottled water now, so everything's okay?
Your Honor, our answer to that is that the only injury facing the VEA is not that of consuming the water. Their soil is also degraded. This is not just a simple issue of purchasing bottled water. The VEA's members and all members of Mammoth community are not only drinking this water or purchasing bottled water, they're showering in this water. The EPA has shown that even exposure to PFOAs in the air can cause cancerous effects. This isn't a simple fix of purchasing bottled water. Additionally, members of the community who cannot afford to purchase bottled water are continuously drinking this water. Your Honors, unfortunately, this is not a quick fix, which is why the VEA has brought this lawsuit to begin with.
Well, weren't you all a big fan of Blue Sky when they started out?
Yes, Your Honor, we believed that Blue Sky would help with the Vandalia Mammoth's issues of landfill. However,
Well, forgive the pun, but, I mean, don't we have to pick our poison?
Your Honors, we would assert that
I
we
mean,
do not
because
pick
it's just
cancer.
laying out there, right? And so they don't do something with it.
Your Honors,
It's gonna be poisoning somewhere else.
Your Honors, the PFOA was not present in Mammoth's soil or drinking water prior to Blue Sky being here. So when we're choosing to pick our poison, we really should not be picking between cancer and forever chemicals and the presence of no chemicals and no forever chemicals. And that's really what we're looking at here. There was no presence of
But
PFOAs
I
in
mean,
the
it's just
soil.
not the world we live in, is it?
No, Your Honor. However, as the Vandalia Environmental Alliance asserts, it is our job as community leaders to ensure that our community is not being poisoned and that we take all measures appropriate to ensure that all corporations follow the law and do not poison their citizens.
You're addressing issue 1 and 2, or just 1?
1 and 2, Your Honor.
Okay. Well, how do you have standing?
Yes. Moving on to issue 2. Issue 2 focuses
Well,
on.
let me ask you a question first
Yes.
about preliminary injunction. Some circuits say that you need a clear likelihood of success on the merits, and I notice you've steered away from likelihood of success entirely. That's, of course, a central component in the winner analysis. How do you react to that?
Yes, Your Honor, and my co-counsel will reach the issues of merits just briefly, but I'm happy to touch on it now. I think when we're really looking at issues of merit, we can see that that issue of irreparable harm really plays a key role here. It's not just an issue of the community purchasing bottled water. This is something that has leached into the VEA soil, and it's not we currently do not have the technology to filter out these PFOAs. This is really an issue of irreparable harm versus a corporation's profits. I'd now like to talk a little bit about issue 2. And issue 2 deals with the special injury requirement under the second restatement of torts. And
Well, and maybe we ought to start with the most important issue there. If surrounding farms have the same concern, how do you react to that?
Your Honor, we assert that the main issue here is determining what correct comparative population we have. And to do that, the second restatement of torts tells us that we must look towards the common right being utilized by all citizens. In this issue, the common right
But
that
this
the
just
Blue
seems to
Sky.
be so particular, though, to VEA. I mean, that's the rub, right?
Yes, Your Honor. And when we look at the comparative population, we look at the common right that all people are accessing. It's that common right to clean air. And because Blue Sky has been polluting the clean air of the Mammoth community, there has been settlements of PFOA deposits on the land and in the water supply. That common right is really being impeded. And when we look at the general population's injury from that common right, we see that the injury is to their personal bodies. It's from consuming this water and getting exposed to carcinogens.
Do you agree that, and maybe you do, that VEA has not suffered a special injury and it's more a public nuisance, public injury claim?
No, Your Honor, we assert that the VEA has suffered a special injury as required to bring a public nuisance claim. While they have suffered similar injuries to that of the public to harm to their bodies, they've also suffered an additional injury, and that's the injury to their private
So
property.
how do they fall under special injury under the law?
Yes, Your Honor. They fall under special injury in two main ways. The first is through injury to their private property, which is recognized under the Second Restatement of Torts as a special injury in and of
So
itself.
restatement's nice, but I mean, has any court said that?
Yes, Your Honor. We can look towards multiple precedents. I'm thinking most importantly of Baptiste v. Bethlehem in the Third Circuit, which stated that even if other private property owners have suffered a similar injury, a private property owner can still bring suit under that special injury claim for public nuisance because the impediment on the enjoyment of their property is so inherently personal that it is a special injury.
And I think we do understand that. I suppose a deeper question I have is, what is the relevant comparison group here? The relevant comparison group for determining whether any injury is special?
Yes, Your Honor. The relevant comparison group in this instance is all citizens of the Mammoth community, both the farmers and those citizens drinking the PSD water. And that's coming from that access to the same general right, the right to clean air.
But if we're talking just about the farms, at what point does a shared property injury become too common to qualify as a special injury?
Absolutely, Your Honor. If we were to shrink that comparative population and really only look at the farms affected in and around Mammoth, we can see that the VEA still has a special injury different and distinct from that of other farms. And that's because their organizational mission has been entirely undermined. Not only are they unable to grow and distribute food, something that is shared by all farms, they're also unable to congregate on their land. They're unable to actually hold educational initiatives on their land, something that goes directly to their organization's mission. It's not just shutting down a farm, it's shutting down an entire nonprofit.
Let me ask you a question about, we focused on special injury. What exactly is the public right that's being offended here?
Your Honor, the public right that's being impacted here is the right to clean air, which is something that's not just experienced by the VEA and farms, but also the entire community at large.
So you don't see any harm in drinking water?
Your Honor, we assert that the right to clean air has been impeded to the point where it has impeded the right to clean water. The initial emissions were into the air, which has then settled on land and water.
But you're drilling down on one particular public right, and that is the air?
Yes, Your Honor.
Understood. Please proceed.
Your Honors, it is for this reason that the VEA has utilized their land in such a special and particular way to forward their organizational mission that we qualify under special injury for bringing a suit of public nuisance. Your Honors, it is for
And the district judge found you did.
Yes, Your Honor. And Your Honors, it is for these reasons that the VEA respectfully asks this court to reverse the stay and affirm the finding of standing on the public nuisance claim. Thank you for your time.
Thank you. Counsel, my first question to you, I may have misunderstood what your colleague took. Which issues are you taking?
Yes, Your Honor. I'll be covering issue 3 and 4 today.
Thank you.
May I proceed?
Please proceed.
Good afternoon, Your Honors, and may it please the court. My name is Jessica Smith, and I'm here today representing the VEA. Your Honors, at its core, this case is about protecting the public from irreparable environmental harm. In pursuant to that interest, I'd like to discuss 2 issues with you today. First, whether or not Blue Sky's aerial emissions of PFOAs can constitute disposal under RCRA. We hold that the statutory interpretation and the language of the text supports a finding that air emissions do constitute disposal under RCRA.
Where in the statutory text do you find support for air emissions followed by land deposit?
Yes, Your Honor. If we look at the text of RCRA, we notice 7 different verbs essentially describing the delivery of solid or hazardous waste onto ground or onto water. We believe that aerial emissions would fall under the discharge or deposit verbs.
So how do you, I mean, is this something that if I would go to Mammoth today, I could look on the farm and see layers of it on the ground, or is it just minuscule that I couldn't see it?
Your Honor, PFOAs are such a toxic and carcinogenic chemical that even very trace amounts have been proven to cause cancer, birth defects, developmental
I
delays.
understand that. It's just, we're trying to understand whether you're going under the right statute. And disposal to means, feels like, I see a truck coming, right? A dump truck with toxic waste in the back, and they dump it, and you can see it. And because it has that sort of connotation, does it in the law, but can you see it when you go there?
Your Honor-
On the ground, or would you walk and think it just looks normal?
Your Honor, if you went to any area that was contaminated by PFOAs, you would not be able to see them with your eyes. However, we believe that the best precedent for this court to follow would be that of Little Hocking Water Association, in which the court reasoned that nobody would argue that if we had a dump truck full of waste and we just dumped it onto these farms, no one would argue that that wasn't disposal under RCRA. And so the court in Little Hocking said that if that
But
is
did
disposal.
Congress use the word emissions in RCRA?
Your Honor, Congress has used the word emit or emissions in RCRA. However, it's our contention that in this case, in the RCRA ISE provision here, the sequence of the verbs in the statute are describing the delivery onto land or water, and then after particles of hazardous solid waste are delivered onto land or water, they may then seep into groundwater or emit into the air.
But does your interpretation sort of run the risk of conflating or blurring the line between the Clean Air Act and RCRA?
Your Honor, this has been discussed before in BNSF Railroad, where they were trying to distinguish the difference between air pollution or particles in the air that were being deposited and creating contamination. And in BNSF Railways, they said that aerial emissions there did not constitute disposal because the complaint there was diesel emissions that the citizens in the surrounding areas were inhaling, and they were complaining of the air quality. However, distinctly different here is that we're not bringing a complaint about air quality. We don't fall under the Clean Air Act because PFOAs are not regulated under the Clean Air Act, and the Clean Air Act is essentially
So
concerned
that's
with.
why you're under this act. You wouldn't have any cause of action under the other one.
Yes, Your Honor, we would not
Okay.
have a cause of action under the Clean Air Act. However, it's our argument that even if PFOAs were covered by the Clean Air Act, there is still a cause for action under RCRA, because the concern here is not necessarily just the inhalation of poor quality air. The concern here is that Blue Sky's smokestacks are emitting PFOA particles that are being delivered through those smokestacks.
Pardon me, let me give you for a moment the view that we're going to allow some overlap. What limiting principle then do we adhere to or apply that prevents plaintiffs from recasting ordinary air pollution claims as RCRA claims?
Yes, Your Honor. I believe that the environmental regulatory statutes set up by Congress are best read as complementary to one another. RCRA was intentionally.
I'll give you that, but where is the line drawn?
Your Honor, I don't believe that it's easy to draw an exact line. I would argue that RCRA.
We may.
It's our contention that the line there is that the RCRA is used for instances of solid or hazardous waste that is deposited in a way that contaminates or creates some kind of pollution, whereas the Clean Air Act is solely about air pollution. And the difference there is that the RCRA was enacted to be essentially a remedial statute. Congress recognized that when they're drafting these legislations, when they're passing these bills, technology continues to advance and they can't always keep up. When they first drafted the Clean Air Act, they had no idea that PFOA contamination would be an issue. That's why RCRA was
Well,
enacted.
but isn't that a problem for Congress and not for the courts?
Your Honor, RCRA was designed by Congress for instances like this, where the existing regulatory statutes don't cover instances of
And-
imminent and
And when
substantial
that
harm.
happens, shouldn't we rely upon Congress then to enact a law, which we then can interpret? And if they don't, should we assume that they've made a decision not to, and we shouldn't get into the business of legislation?
Your Honor, RCRA is the law that can be interpreted for a situation like this, because when we have these instances of pollution that, if not halted immediately, will cause forever irreparable harm, we can't wait for Congress to draft a new statute. That was their purpose with RCRA, was acknowledging exactly what you just said, that right now, there's not always a precise law in which every instance of irreparable environmental harm can be regulated. And when Congress can't act fast enough, the court can use a remedial statute like RCRA to prevent irreparable harm in that absence of a more delineated air pollution
It
regulation.
just seems that the courts are being asked constantly to correct the inadequacies of Congress. And maybe that's just not our job. Or maybe someone will elect different people to Congress.
I couldn't agree more with my colleague. I know that your time's expiring. How about if you move on to irreparable harm?
Yes, Your Honor. Irreparable harm under the Winters factor requires for a preliminary injunction for the plaintiff to show irreparable harm to themselves. However, once a plaintiff establishes irreparable harm to themselves, in cases of environmental harm, precedent shows that the plaintiff is able to pull on public harm to substantiate that. We recognize that the 4 factors of Winters are conjunctive. They must be satisfied independently. There has to be public harm and plaintiff harm.
Do
However,
we give any deference to the district judge's finding on those factors, or are we de novo?
I believe you would be de novo
Okay.
on these factors. We recognize that each factor must be substantiated and satisfied independently. However, here VA has shown clear irreparable harm. The PFOAs that are in our soil right now will never go away.
And that is unassailable. I don't think anyone disagrees with that, but things are a little bit more complicated than that. Where, in fact, does Winter allow for an irreparable harm analysis of non-parties?
Your Honor, if under a MoCo production code, we did reject the automatic assumption of irreparable harm for environmental injuries. However, that court noted that environmental injury is often permanent and cannot be remedied. And because of that, when you're dealing with an issue of environmental harm, because it is such a public issue that impacts the entire community, once a plaintiff can establish their own standing under Article 3 and under RCRA and under the Winters test, they can substantiate that standing with the public interest. That's why there is a public interest
Does
with.
anything exist today to remediate these forever chemicals? Or is our best hope just to stop it as quick as we can?
At this time, there are certain filtration technologies being developed for water. There are no current technologies for filtering out this water in Mammoth, and it would take, according to the record, about 2 years before any filtration system would be put in place. Our experts have testified that at the rate it's going now, in those 2 years, the amount of PFOAs in our water and in our soil will rise from the current 3.9 parts per trillion to 10 parts per trillion.
Understood. And I would ask you, though, I'm still concerned about this public harm approach because it seems like it moves Winter into an unmanageable territory. If any organization, for instance, could obtain an injunction simply by identifying members of the public who face a risk, even if its own members face none, where does that end?
Your Honor, I understand the concern, but I believe the reasoning here applies to a rather narrow set of cases. We're just talking about cases of environmental harm that impacts an entire community. Here, we have established that harm to the VA itself. However, RCRA expressly authorizes citizen suits to address this imminent and substantial endangerment to health or the environment. When Congress wrote this statute, they built public protection into the language. Courts have recognized that when a statute is designed to prevent public harm, irreparable injury to the public can satisfy or substantiate the irreparable harm prong of the Winters test. So once VA established injury to itself, including the contamination of its soil, the contamination of its water, its inability to take out its organizational mission, it can invoke public interest in preventing broader environmental harm. Those who aren't aware or can't afford to drink bottled water, remain consistently poisoned by the water they're drinking every day. The reason we invoke public harm here is not because we don't have harm to ourselves, but just because the Winter test does include a public interest factor, and that public interest can be used to further substantiate the irreparable harm.
Understood. Let's talk about imminence. The toxicologists, I believe, testified, and you may have mentioned it before, about potential increases in contamination levels down the road. Why is that not more of a speculative as opposed to the required imminent injury?
Your Honor, I believe these statistics come from the testing that we actually have already done. Right now, we are at 3.9 parts per trillion.
I understand.
A year ago, we were at 0. And so essentially our experts
But you only have 1 year, a 1 year look back period. is there any possibility that some other contributor, unrelated to Blue Sky, was responsible for this deposit?
Your Honor, it is certainly possible that further discovery might show that Blue Sky is not the direct contributor to these PFOAs. However, right now, the correlation between the beginning of operations of Skyloop and the sudden increase and dramatic
That's a correlation, that's not causation, and the concern is you're, shutting down this entire investment, and it seems a little bit speculative based on such a brief look-back period.
Your Honor, at this time, since we have not gone through discovery, there are elements
And
of
I understand that,
speculation.
and that's a matter to be addressed later, but you have a preliminary injunction in place, and the requirements are very strict for that. As I said, some circuits require a clear likelihood of success on the merits. So does that not trouble you?
Your Honor, it doesn't trouble me because at this time, we can see that the beginning of operations of Skyloop's facilities correlates precisely with this increase in PFOAs. And we know that the emissions from Skyloop do contain PFOAs. We know that the standard winds of the area would direct those PFOAs from the aerial
So, Ms.
emissions.
Smith, at the preliminary injunction hearing, did Blue Sky offer any evidence, any expert evidence, toxicologists, to dispute your experts in this matter?
No, Your Honor.
Did they concede that what you say is correct?
They conceded that there are PFOAs in their emissions.
Okay. Did not concede anyone's been harmed?
They have not conceded any harm. However, there's been recognition from both sides that PFOAs are a forever chemical that do cause irreparable harm to the health and to the
Of course,
environment.
they're saying it's not irreparable because they're giving bottled water to everybody.
Your Honor, I do see I'm at time. Do I have permission to respond?
You can answer that question then.
Thank you, Your Honor. At this time, the harm is irreparable, not just because of the bottled water. It's irreparable because even if you can drink bottled water, you still have to cook with contaminated water, bathe with contaminated water. Imagine if you had to have your entire water supply shut off for an indefinite amount of time, completely out of your control. There are certainly elements of this contaminated water and soil that will continue to irreparably harm VEA, even if they do have bottled water. May I briefly conclude?
He's the chief, but go ahead.
Thank you, Your Honor. Blue Sky is emitting PFOAs into the air. These particles are being delivered to land and water through these aerial emissions, which does constitute disposal under RCRA. The resulting contamination poses an imminent and substantial harm to the environment, the community, and the VEA. Environmental harm of this magnitude is irreparable, and RCRA permits courts to consider harm to the public in granting injunctive relief. For those reasons, we respectfully request that the district court's issuance of a preliminary injunction be affirmed. Thank you, Your Honors.
Thank you for summing up timely. And we'll call now on your opponent.
Yes.
Please proceed.
May it please the court, my name is Kira Figgins, and I am joined by my co-counsel, Rachel Banky. We proudly rise on behalf of the appellee, Blue Sky Hydrogen Enterprise. Of the 4 issues before this court today, I will be addressing the first 2. First, that the district court correctly stayed its proceedings pursuant to the United States Supreme Court's holding in Coinbase against Bolesky.
But the district court really didn't want to, didn't he say that?
Absolutely, Your Honor, they did. However, and particularly in distinguishing the case that opposing counsel references, Inkin against Holder, decided by the Supreme Court in
You know,
2009.
I don't even know why we're talking about Coinbase. I think it's just way off base. Excuse that. But it's, in Coinbase, they were talking about threshold jurisdictional issues, arbitration, and now, at least Fourth Circuit talked about whether it should be in state court. There's no issue that we have jurisdiction. This is a federal regulation, and we should be deciding it. And so why shouldn't district courts, who are finders of fact, that's what they do the job well, why shouldn't that issue stay with them, and why should we wait for an appellate court that will drag this out, quite frankly, when people are being harmed?
Yes, Your Honor, and to that end, there's 2 points of response. First, we can turn towards Federal Rule of Civil Procedure 1. The very basis of federal rules is fast and efficient usage of justice. Now, that's not what we have here. If we have in
No, we
this case.
don't. The district judge did it, but
Well,
it's a long time for us.
Absolutely, Your Honor. To that end, effectively what we have created by this case is we have a party having to fight on two fronts, both in the district court level and in the appellate court
Well, you all
level.
don't dispute that you're poisoning the water and air. I mean, you didn't offer an expert to dispute that, did you?
We did not, Your Honor. I do want to
Then what's
direct,
the issue?
I do want to direct this court's attention that Blue Sky is currently enjoined from its operations. There is no harm currently going out into the public, as Your Honor correctly noted earlier.
I thought they stayed then.
Yes, Your Honor. So to level set the procedural posture that we have before this court, VEA moves for an injunction against Blue Sky,
Sure.
which is granted, and then Blue Sky moved for a stay order. But
Which
according
was-
to Federal Rule of Civil Procedure 62C1, unless a district court expressly states that that stay order or that preliminary injunction is also affected, then the preliminary injunction stays in effect. Therefore, under the record, as Your Honor correctly noted earlier, the injunction is still in place. Blue Sky is currently enjoined from its operations and has every incentive to get to trial just as much as VEA does. Now, particularly as it relates to these questions of
Well, then
jurisdictional.
why ask for a stay? Why not just go to trial? I mean,
Yes, Your
that's what
Honor.
you want.
Your Honor, and the stay is appropriate because it prevents that duplicative litigation, particularly in Coinbase
Well, do
against.
you really think we should be trying factual issues like that when, quite honestly, appellate courts aren't that good at it? I mean, it's district courts who are finders of fact, who live with the public every day. It's the job we do. Appellate courts read the law. We're fact finders. We're in the community. I just think you're in the wrong place.
Your Honor, to that end, particularly turning this court's attention to the second issue before this court, it's a standing question. That's a question of law and absolutely belongs within the purview of an appellate court.
Standing
Furthermore,
because of why? Because of Coinbase?
standing under, Your Honor, in order to establish standing under a public nuisance claim, the party has to establish that they have a special injury.
Okay.
Therefore, standing is in this case, and that does amount to a question of jurisdictional significance. Particularly, Griggs classifies that a district court is divested of its authority when the matter or the appeal concerns whether the district court can proceed at all. And that's exactly.
Pardon me, counsel, Coinbase was about forum entitlement. It just seems far off the mark.
Your Honor, to that end, directing the court's attention to Justice Kavanaugh's majority opinion in Coinbase, he expressly states that the result here does not create a special arbitration preferring rule. Rather, it expands it to the questions we've seen in previous cases, which is referencing Griggs. And that's that language, any event of jurisdictional significance. We will easily concede that when it comes to jurisdictional significance questions, that includes questions of qualified immunity, standing, those questions that we have before the court. And particularly, I think it's important here to distinguish the case that was referenced by my opposing counsel, Inkin against Holder in 2009. Now, Inkin against Holder allowed discretionary factors to be established at the district court level because they were concerned with the status quo needing to be maintained. Because the preliminary injunction is still in effect, the status quo in this case is being maintained. There's no need to ever get to Inkin or get into the discretionary factors in Inkin. We never reached that area of analysis. Further, Inkin concerned an immigration case, whether an immigration policy allowed the deportation of individuals. And this discretionary application, as
So
it
what is it that you want us to do then? Do you want us to say that they didn't have standing and that the court had no basis to issue a temporary injunction?
Your Honor, under second issue, we would ask this court to find that there is no standing under a public nuisance claim. And if this court finds that there is no standing under a public nuisance claim, and that the statute of RCRA, what they've alleged, does not apply here, their entire claim collapses. That's the very issue. There's nothing to go forth for the trial court.
So you're arguing that there is no remedy under the law for what you're doing to the water and the air?
No, Your Honor, there is private nuisance claims. That is not what has been alleged before this court, though, and that is not the certified question before this
Do you
court.
think a private nuisance claim could be established?
It very plausibly could, Your Honor. However, because the claim is public nuisance, there's a particular policy concern with that. There's advantages to pleading a public nuisance doctrine, such as my opposing counsel has already done in accessing the harms to the public. I further think it's super important to clarify at this point that what VEA has alleged, the public right they say has been interfered with at the district court level was the public water. That's in the record at 15, paragraph 1. Now,
And I asked that question, you may remember.
yes, Your Honor, and to that end, opposing counsel answered to you that the public right being interfered with was the clean air. That's not what they alleged at the district court. That's not what the district court held.
Well, what can be more public than clean air and clean water?
Your Honor, we aren't denying the public nature of clean air and clean water. However, it particularly relates to the persuasive authority we find in Restatement of Torts, Section 821C, Comment B, in which case the special injury has to arise from the public right being interfered with. Because there's no finding that the public right to clean air was interfered with, harms can't come from clean air. There's nothing in the factual record to indicate that VEA members are breathing in these toxins, that it arises to a Clean Air Act case.
Well, it's clearly in the water, which you all acknowledge because you're providing bottled water, right?
Your Honor, to that point, with the record, in the record, VEA's harms they alleged, as the record reflects on 15, is not water. They do not say that their special injury comes from the water.
Sure,
They
but-
say it comes from soil contamination.
Sure, and the way this all goes about is that the contaminants are in the air, which then fall and get into the soil, which is what causes the harm. Is that correct?
Your Honor, my my co-counsel will address the
Okay.
necessity of the subsequent order that's required in RCRA. RCRA does not apply to this case.
Talk
But
about your view, if you would, about the contamination of the private land, why it doesn't qualify here.
yes, Your Honor, so we can particularly turn towards a case called Arizona Copper against Gillespie, decided by the Supreme Court in 2019. I think it's important to reference here that opposing counsel utilized Baptist against Bethlehem, decided by the Third Circuit. SCOTUS has effectively overturned Baptist against Bethlehem by their holding, and the SCOTUS authority is stronger. In Arizona Copper, they specifically stated that when multiple landowners are experiencing the same alleged contamination, that injury is not special merely because one plaintiff gets to the courthouse first. And so Arizona Copper is what really controls here. And we can see that when it comes to private land contamination, that does not arise to a special injury effective in order to establish a public nuisance claim.
But what about if there are a number of individuals who suffer that, but not so high a number maybe that, it's going to fall within the case you're speaking about?
Your Honor, when it comes to the amount of people that have to be impacted, the quantity, that's less the test before this court, and more the test is that it has to be different in kind. That's why the status is not only different in degree. I further want to emphasize that the record never reflects that VEA members use the shower water, that they use the water to cook with. The only thing the record tells
What would
us,
they use?
Your Honor, the record is silent as to that matter. It does not say it one way or the other,
Think
though.
they drive to another town, or?
Your Honor, and there's the possibility of private well fields. The record simply is silent either way, though.
Okay. Okay. But isn't VEA in itself it's a public organization? I mean, it's a group, it has a collective farm, and they train people, which is good for the public. They sell their vegetables, which is good. And aren't they, don't you think they're distinguished as a party from just an individual?
Your Honor, that's a great question. I'm glad you asked it, because when it comes to nonprofit organizations or advocacy organizations, they cannot allege a special injury, as this court's precedent has emphasized on multiple occasions.
But they can be both a nonprofit and also suffer injury, in that they can't grow their vegetables now because they'll be contaminated, and then they train other farmers to do these things.
Absolutely, Your Honor. And while a nonprofit can bring harm when it suffers a concrete harm, that's not what we have here. We have a
Give me an
nonprofit
example
that's.
in this case that would be a special injury, because it just feels like you don't think anything would.
Yes, Your Honor. So we can particularly turn towards the case of Little Hawking Water against DuPont, decided by the Southern District of Ohio in 2015. In that case, it was nonprofit entity that was providing the water. As a result, that nonprofit entity suffered a special injury by their water being harmed. That's because of the reputational impact. But we do not have that here. If we allow advocacy organizations to avail themselves, to give themselves standing effectively, it collapses public nuisance doctrine entirely.
Where in the record is there evidence that numerous other farms have suffered the contamination?
Yes, Your Honor, we see that reflected in the record on numerous occasions, particularly VEA, I believe it's at record at 4, even states that they acknowledge, VEA admits that other farms are likely similarly impacted to them.
Likely and potential and possible, those aren't the types of characterizations that are particularly helpful to you, I don't think.
Your Honor, it goes for, particularly if we turn towards footnote 2 of the record, it states that VEA is positioned 1.5 miles downwind of Blue Sky's facility. Now, they emphasize that there are other farms between them and Blue Sky. Logic dictates that if PFOA through the air and through the wind, as the record explains at 8, are landing on their farms, then it's landing on other farms. Rather, VEA, because of their environmental knowledge and their ability to test and have access to those materials, that doesn't allow them to get to the courthouse first. That's the very concern that Arizona Copper warned against. And
Well, would you concede if there was contamination unique to the VEA farm that we would be in an entirely different situation?
not exactly, Your Honor.
And explain why that's the case.
Yes, Your Honor. If it was unique contamination that resulted in an injury that was different than any other injury of the farm, then we would concede. But it's that injury precipice that we find that threshold test on. And particularly because VEA cannot establish a special injury, an injury that is different in kind, they cannot assert those rights. And even today before you, my opposing counsel has only argued that they have harms arising from air rights, not water rights. And as their statement of torts emphasizes, it has to be the harm for the public right that's being interfered with. The only factual record that indicates the public right being interfered with here is water. That's why the district court applied the comparative.
But how can you separate the air from the water? Because it's getting into the ground from the air, which then affects the water. It just seems like splitting hairs.
Your Honor, while it may be splitting hairs, that's the very emphasis that the restatement of torts ask us to give. And that's what the district court did when they stated that the comparative population was residential users of Mammoth's water. Under the very comparative population the district court gave and the argument opposing counsel gave you today, they have no special injury. They have not alleged any harm that uniquely and distinctly comes from water, only air. And it is to that end that we can see that there is no special injury. And that is the splitting hairs or the requirement that the district court and the restatement of torts ask for us to make, because it has to be that public right that is being interfered with. And further, my co-counsel will emphasize why the subsequent order of RCRA, the requirement that there must be deposit of this chemical into the ground and then emissions, is critical to our analysis. However, RCRA does not apply in this case, as my opposing counsel will make clear. And it is for these reasons that we ask the district, I see that my time has elapsed, may I briefly conclude?
Absolutely.
We ask this court to affirm the district court's stay order and to vacate the district court's finding that VEA has a special injury sufficient to establish standing under a public nuisance claim. Thank you.
Thank you, counsel. Please proceed.
May it please the court. My name is Rachel Banky, and like Ms. Figgins said, I'll be addressing the third and fourth issues before the court today. Why the district court erred in determining that the VEA is likely to succeed on the merits of their claim, where the plain face and the plain language of the statute doesn't cover air emissions. And further, why the appellant is not entitled to a preliminary injunction in failing to demonstrate suffering and irreparable harm. Your Honors, this case is not about whether or not PFOA contamination is concerning, and it's not about, quote, halting an inept corporation. This case is about whether district courts may stretch a waste statute beyond its text and issue extraordinary
Well, the
relief.
statutory definition includes the word placing, doesn't it?
It does.
So why does that not naturally lead to the conclusion that deposition from the air qualifies as placing on the soil?
Because what we're talking about is not deposition from the air. It's an air emission. It's the spreading of a particulate thin matter that you can't see with the naked eye. It's not a placing in the sense of we think of a sludge.
When public health is taken into consideration, though, shouldn't we give that term a little broader construction than you're giving it?
Your Honor, public health on its face is not carte blanche for courts to legislate from the bench and read words into the statutes where they don't exist. But even under a liberal view of the statute, emissions don't come within RCRA. They can be found in other parts and portions of the statute, but not in the disposal clause.
Your opponent said that emit or emissions is in the statute. Do you wish to react to that?
I do, Your Honor, and I'm glad you asked. You asked my opposing counsel, where in the statute does air emissions appear? They answered that it appears in the sense that discharge and placing, those verbs are used. However, Your Honor, in the statute at hand, the disposal clause, the word emission only appears in a sequential order, and it's really not the word emission. It's to be emitted into the air after it's been deposited onto the ground.
So how do you distinguish admission from to be admitted?
Well, Your Honor, obviously, one is the verb and one is the noun. And the particular use of the word to be emitted in this use in this statute is part of that sequential order. In other words, the disposal occurs and then an emission can occur. That's further supported by the use of Congress's language.
So things are out of order here. Just because it's falling out of the air and then disposed, it has to be disposed and then admitting is your argument.
That's absolutely right, Your Honor. And that's a fact my friends and I across the aisle agree on.
And so let them drink bad water.
Your Honor, that's not at all the
Let
result
them
here.
breathe bad air.
That's not the result here, Your Honor.
What's happening, and you have not presented any experts that dispute what their toxicologists have said.
Your Honor, that is true. We haven't presented toxicologists.
Is it
But in
because you
looking,
don't have any?
I'm sorry, Your Honor?
Because it's just true?
Your Honor, we're not conceding that that's true at this point.
Okay.
But it's important to recognize the procedural posture of this case. That was at a preliminary injunction hearing. Here we haven't had the benefit of discovery, of a trial on its merits, a jury of our peers, and all of the processes that occur in preparation for litigation. But in addition, that's the VEA's burden to put on that evidence.
Did you ask for the stay?
I'm sorry, Your Honor?
Did you ask for the stay?
No, Your Honor, we did not.
Okay.
However, here, Your Honor, in talking about the RCRA statute, the focus of issues 3 and 4.
Yes,
If-
let's get back to that. And I wanted to ask you, what cases are you relying on for your interpretation?
Absolutely, Your Honor. There's 3 separate canons of construction that support Congress's exclusion intentionally
But
of the
what
word
are the
emission.
cases you're specifically relying on?
The first would be Ford versus United States from 1927. The second would be Russello versus United States. And the last would be Loughran versus United States, a 2014 case. Now, in each of those cases, the court examines a different kind of canonical construction. The first we'll take in turn is Ford versus United States.
Well, I'm not so much interested in the cases and their general methods of statutory interpretation. Tell me a little bit about the Little Hawking case.
In Little Hawking, Your Honor, that was a district court case which ruled in contrast to our Ninth Circuit's decision in BNSF Railroad. Now, the Little Hawking case decided that C8 particulate matter, which was emitted into the air and fell onto the ground, constituted disposal. However, the Southern District of Ohio incorrectly applied the definition of disposal, and instead, we urge this court to adopt the Ninth Circuit's interpretation of disposal.
Well, from a factual standpoint, the Ninth Circuit decision, a combustion byproduct from a locomotive, seems a little bit inapposite here. Isn't the Little Hawking case a little closer to what we have going on here?
Perhaps it could be in the sense that it uses particulates, but particulate matter is present in the BNSF case as well. In BNSF, we're talking about diesel exhaust emissions still going into the air and being emitted from the defendant's rail yard. And the court held there that based on the sequential order dictated by the statute, that doesn't constitute disposal. The reason behind this, Your Honors, is if we were to read the word emissions into the statute, it would convert RCRA into an all-purpose air pollution act.
But this is remedial legislation. It's entitled to a broad interpretation. How do you react to that? That's one of the longest settled statutory construction rules that we have.
And isn't it meant to be a remedial act?
It absolutely is meant to be remedial. What it
Okay.
is not meant to be is a blank check for plaintiffs to bring a claim under instead of proving or pleading other causes of action. In talking about one of the most common canons of construction, the surplusage canon, we know that every word and every meaning must be given effect. It is the cardinal principle, like our Supreme Court recognized in Lawford versus United States. Here, if this court were to read omissions into one of those verbs, it would make the sequential order necessary for the statute, a fact my opposing counsel and I agree on, obsolete. It would read in a different order recognized. But in addition,
Do
Congress's
we
intent...
have anything that might suggest in the legislative history that Congress intended a very broad application?
To the opposite is true, Your Honor. RCRA was amended to include Section 6924N. There, a section, a carve-out, was added for air emissions. Congress knows how to use the word emissions. They use it at 6924, and they use it later at 6991-8 in talking about emissions and release. They're familiar with the word, but they chose not to include it in the statute at hand because they didn't mean for it to come into that place. Your Honors, in the Section 6924N, Congress specifically carves out a section titled Air Emissions. That section of the statute was meant to give the EPA room to promulgate regulations surrounding air emissions. We understand that the Clean Air Act doesn't cover these PFOA chemicals, but here, particularly where the movement is alleging an offense of a clean air right, this doesn't come under RCRA.
What act would cover the forever chemicals?
Well, currently, Your Honor, CERCLA mentions the use of forever chemicals, and perhaps that the EPA we know is working to categorize these PFOAs in other sorts of senses for max contamination levels.
So we just need to wait.
Well, Your Honor, we don't need to read it into RCRA. If there's an issue with Congress, that's an issue for the movement to take up with Congress, not with this bench.
That takes time, counsel, as you might expect, and what we're dealing with here with these forever chemicals is a matter I think all would agree is of urgent public health concern. And I suppose what I'm struggling with most is, would your rule mean that identical contamination pathways would be treated differently depending on whether the waste is first placed on the land or first emitted into the air? That really seems to be slicing things very fine.
Yes, Your Honor, that is what we're asking. And I sympathize with Your Honor's concern that it seems like we're slicing things fine. But that's what statutory interpretation requires. RCRA relates to
In a remedial statute?
It's a remedial statute for ground and water contamination, not air contamination. That's why the order of disposal is so important here. And I'd like to remind the court that that's a fact me and my friends across the aisle agree on. There is a sequential order to the statute. Otherwise, it's an all-purpose air pollutant act, which is not what RCRA was intended to serve.
I think we understand your position on that. You can move on to irreparable harm if you like.
Understood, Your Honor. Moving to my second point, a generalized public injury without more, as the VEA has pled, is insufficient for the granting of a preliminary injunction. Your Honors, as my opposing counsel has recognized, plaintiffs must first demonstrate the harm, the irreparable harm to themselves first, and then in some circumstances may invoke the interests of the general public. Your Honors, the test that they have brought, or the claim that they have brought, an ISE claim under RCRA, is a high claim. It has a strict test. The standard that our Supreme Court set out in Winter versus NRDC is a high burden.
Well, they can no longer use their farm, which was used for many purposes. Who's going to want to eat anything that comes out of that ground right now? And how can they train the people that they train? How the community eat what they've been providing? Why is that not irreparable?
It's important to note from page 13 of the record, Your Honor, that at our preliminary injunction hearing, the VEA relied solely on the harm produced through drinking water. The harm concerning the soil or the farm was not pled or argued and has been waived at this point. But further, Your Honor, any harm through that bottled water or that farming can be a compensable harm, not an irreparable one. And that takes me further into my argument.
Well, but what happens to people as a result of forever chemicals is irreparable. If you suck it in and once you have cancer, you do. And you can compensate everyone you want, but that doesn't seem fair.
Your Honor, we don't have evidence from the record before us today that anyone has developed adverse health effects. There's
Any
been,
dispute that the chemicals that we're talking about does cause these harms, though?
we understand they have the potential to cause that harm.
Okay.
Absolutely, Your Honor. We're not debating whether or not these chemicals are concerning. What we're talking about is issuing extraordinary relief, as our Supreme Court calls it, without injury that's tethered to the movant's interest, without meeting the super high standards set out by our Supreme Court, irreparable harm. And here, appellant can't
Is it
demonstrate.
your position that that irreparable harm always has to be suffered personally by the named plaintiff, even in public interest litigation?
It does to start, Your Honor, yes. That's the essence of standing. A plaintiff can't bring a claim where they've suffered no harm.
Well, how do you reconcile that position then with environmental cases where courts issue injunctions? I'm not talking about Article III standing, where they issue injunctions to prevent ecosystem damage or wildlife injury.
Even in those cases, Your Honor, courts still require harm to the plaintiff. An example of this is seen from the Eighth Circuit.
Well, I think we can have harm to the plaintiff. I think we have harm to the plaintiff here. The question is the question of irreparable harm.
Yes, Your Honor, and that's not present here. And that's supported by the Eighth Circuit's holding in 2025 in Beber versus Navsav Holdings.
But why do we, if we know that irreparable harm is happening to a citizenry at large, but we may not have that precisely to the plaintiff who's named in the style, why can't a court reach out and address that in public interest litigation?
Because it's the plaintiff who's named in the style who's bringing the suit. They can't claim irreparable harm on behalf of another, which is not tethered to themselves. If that's the claim, then the citizens at large should bring a claim. But here, for the VEA...
So I want to make sure I understand. Are you arguing Article III standing principles here or something different?
Article III standing principles are, of course, always at issue. But further, Your Honor, it requires standing where Congress has empowered citizens to step in. So there would be both. Article III is always present, but that special injury, as Ms. Figgins argued earlier, would be relevant here as well. I'd like to direct this court's attention to the Eighth Circuit's decision from Beber versus Navsav Holdings, where our Eighth Circuit held that courts consider the threat of harm as it relates to the movant in this injunctive relief context. Again, National Wildlife Federation versus National Marine Fisheries
If we
Service.
accept your argument to the logical extreme, then would we just have to wait until someone has cancer 5 years from now, then they can file something?
No, Your Honor. Perhaps a negligence suit would have been more appropriate here. If they feel that Blue Sky's not acting as a reasonable company should in the circumstances, a negligence suit may be a more appropriate suit to cure what Your Honor is concerned about, this risk of cancer. Now, we're not ceding liability to negligence here, but the point is it doesn't fall under RCRA because they don't meet those high standards set out by our Supreme Court in winter.
Well, we're focused on irreparable harm right now, and if harm to the public is irrelevant, then why is a court, in the context of the relief that we're speaking about, why does a court weigh a public interest factor?
Your Honor, we weigh the public, I see my time's about to expire. May I answer your question and
Certainly.
briefly conclude? We weigh the public interest factors in factors 3 and 4 of the Winters test. That's because it's an equitable remedy. Now, Blue Sky has ceded factors 3 and 4, so those aren't at issue before the court today. But the issue of irreparable harm is necessary to the plaintiff before it goes to members outside. And here, the district court found that there was not enough evidence to suggest the VEA is likely to suffer irreparable harm between now and the time of trial. Without that necessary irreparable harm, and where they failed on the first conjunctive prong of Winter, is where preliminary relief was improperly granted. So we ask this court vacate the order and reverse the decision of the district court. Thank you very much.
Thank you. Counsel, you may proceed.
Thank you, Your Honors, and may it please the court. I want to briefly touch on two issues, Issue 2 and Issue 3. When revisiting special injury, I want to touch on this case, Arizona Copper Company v. Gillespie, something that my opposing counsel briefly mentioned. Now, this case was from 1913, And this actually emphasizes what special land use means when a plaintiff brings that action under public nuisance. In this case, we saw a private farm owner who brought a public nuisance claim because his irrigation system on his farm had been entirely polluted by an upstream mining company. Now, the special use that this farmer had implemented on his land allowed him to bring that special nuisance claim. In the instance here, we see that the VEA has, again, a special use of their land. Not only are they farming, like other farms in the area, like other farms were farming in the area in Arizona v. Copper, but they're using that additional special use of their land to pursue their organizational mission. And we can see
Did
that—
the contaminated water in the Arizona case compromise the growth of the plants?
I'm sorry, can you repeat your question?
In other words, I'm wondering about the Arizona case. Did that compromised water supply kill the plants or harm them in some way?
Yes, Your Honor, it did.
And are the PFOAs harming the vegetables here as far as their growth is concerned?
Your Honor, the harm here to the vegetables is to the fact that they will have those PFOAs in them, and it is unsafe to consume and distribute them, something that is core to the VEA's mission. I now want to talk briefly about issue 3, this RCRA issue. Now, opposing counsel would like you to believe that they can just have a blank check to emit things in the air, and suddenly that makes
Do you
it—
see a more immediate injury in a plant expiring as opposed to a plant having something latent on it but still growing?
Your Honor, I don't think that that distinction should be a concern for the court. In both instances, the plants cannot be consumed and cannot be distributed. The error there, or the issue there to the produce, is the idea that it can no longer be consumed in any aspect, whether that's because it's
What I'm
toxic—
getting at is whether there's a distinction between the Arizona case and your case. I'm not saying that you're wrong, but you're placing a lot of stock in the Arizona case, and I'm not sure that's justified.
Yes, Your Honor. I think the real similarity in facts there between our case and the Arizona case is the fact that there is a special land use by the plaintiff in each instance, surrounded by other private land use. Your Honors, I see that I'm at time. May I finish answering your question?
Certainly.
and
Please
conclude?
sum up.
Thank you, Your Honors. In Arizona v. Copper, there were also private landowners who suffered a similar injury. However, because the plaintiff had a special land use, which was this irrigation system, they were able to bring that action under public nuisance. We see here, again, farms may suffer similar injuries. However, because of the VEA's special land use, like that in Arizona v. Copper, the VEA has that special injury and is able to bring a claim under public nuisance. Your Honor, it was for all of these reasons that the VEA asks you today to reverse the stay, affirm our standing, and affirm the preliminary injunction. Thank you so much.
Thank you, counsel. Well, I think they deserve a round of applause.
There you go.
Well, counsel, Judge Alloy and I are going to go back and discuss some matters, but I think the Fourth Circuit is the last of the circuits that still has the judges come down and shake hands with counsel. And even though we're in a fictitious circuit, we're going to go ahead and do that. So. be seated. I'm going to defer to Judge Alloy to provide some feedback first to the lawyers.
Yeah, and for all of you who may not know, Judge Volk is the Chief Judge in the Southern District of West Virginia. I'm a United States Magistrate Judge here in the Northern District, so of course, we always defer to the Chief Judge, and when he defers to us, then we defer to him and do what he says, right? Right. I have to tell you, really, just what a just really a joy to listen to all of you. I mean, they were really just outstanding arguments. All of you should be really, really proud of how well you've done. You know, in our work, I think this is really the most important work, probably even as important, if not more important, than trial work, because you're going to be filing motions before the court all the time. You're going to be making arguments, even if they're abbreviated. You're going to be writing briefs. And so it's just so critical. And I'm sure this has been said to you before, but really your briefs are kind of everything. This is, when we ask questions, it's helpful to bring some clarity, but your writing is where you're going to win the argument. You can lose it on oral, but you know, so just to say that. But y'all were just outstanding. And then Isabel and Jessica, you know, just for both of you, your eye contact was excellent. Really, your speaking voices were great. How you presented it. That's so important because it's not that if you're not doing that, then it becomes a distraction. And if it becomes a distraction, then we're not hearing your argument in a way that we should. So you didn't have anything that did that. I thought you certainly were leaning into the equities of your argument, and you should, right? They may have the law on you, I don't know, but you certainly have the equities, and so I thought that you argued that well. I do think it's always important, you know, that the courts do ask questions for a reason, and they ask the hard ones because those are the issues that we're struggling with, and we need your help, right? And so, and I thought all of you did this well, but yeah, celebrate questions and celebrate the hard ones because we have to make that hard decision. And so to the extent that you do that, you help us with that. And so I thought that you really responded to those questions, but it's real important to, you know, your default is to want to go back to your argument. But it's got to be to answer the court's question because that's what we're struggling with. And may not seem important to you, but if we're asking it, it's important to us. And so we need to deal with that. But I thought all of you in that regard, your presence, your presentation, your knowledge of the law and the facts was just really outstanding. And, you know, again, for you all, I thought you were just outstanding in how you held the line on, you know what? Our job is to follow what the law is, what Congress has said. And do we creep too far when we do that otherwise? And we have to be careful of that. And so I thought that you really played to your strengths. And I have to tell you that you really caused me, at least, to think about it very differently. And I think that's what you want to do with judges, at least to hear your argument and to understand that in a context. So really, you know, we see this all the time, at least for me. There's no one better than what you guys have presented. You know, you really were just outstanding. And so you should be proud of yourself, the universities you represent, and it's good to have you here in West Virginia. Thank you. Yes.
Thank you, Judge Alloy. One thing that I liked that you did was smile. And, you know, some might think that off-putting, but judges have egos. And if you can engage with the judges, it can be very meaningful for your argument. Judges, I hate to tell you, oftentimes have their minds made up or a strong lean before they go in. And the argument still matters, like Judge Alloy said. And One other thing that you might do, beyond being congenial, is refer to what a judicial colleague said at an earlier point in the argument. Again, I hate to use the word ego because it has an unfair connotation, but to say, as Judge such and such suggested, that can be very helpful to you, I think, as well. But you had a very well-structured presentation. It made your theory of the case easy to follow. Your opening roadmap was particularly good, and you demonstrated a strong command of the governing legal framework, and especially the standards that were relevant, which is very helpful. Appellate judges are all about standards, especially standards of review. But you maintained excellent professionalism and composure throughout the argument. And that's a big thing because one of the things we test, I don't know if all of your judges have tested it this week, is we might throw you a couple of oddball questions that might lead you to believe, wait, you know, do they even know what my argument is? Do they even know who I am or who I'm representing? And I have to tell you that that happens sometimes. Some judges are more prepared than others. And how you handle those questions to not be offensive or not correct the judge says a lot about your posture at the podium. So,
Yeah, and I did want to interpose. The difference between Judge Volk and I is his oddball questions are intentional. Mine are unintentional, but he has a reason.
you did an excellent job of explaining how the legal principles applied to the facts of the case. You handled questioning effectively. I think you may have gotten the toughest questions. You may have even gotten a couple of oddball questions from me. I shouldn't have done that, but I did. But you communicated clearly at a very appropriate pace. That's helpful, especially someone like me who has difficulty hearing at times. And you had confidence at the podium. You weren't easily flustered, and you were polished and well prepared as well. You delivered a very well-organized and persuasive argument all across the board. Did a fine job. You effectively framed the case from your client's perspective. You answered questions, but you weren't distracted by them, and you did a good, strong job of connecting legal doctrine to the facts of your case. Again, you engaged well with the questions from Judge Alloy and I. You maintained a calm and confident demeanor throughout. That was a real standout with respect to your argument. So you overall were very effective and extremely well prepared. I would say that as to all of you. You demonstrated a very strong familiarity with the factual record and the standards as well. I always like to ask a couple of record questions because usually advocates are very prepared for legal argument, but when they have to go back to the appendix, judges a lot of times are more interested in the facts at the appellate level. I hate to say it, but that's what I've found in watching it. You also responded very well to questioning and maintained your poise. You had a clear professional tone throughout your comments and the argument. And again, like with all four of you, I could see that there was strong preparation and high confidence throughout. But again, you two had a very polished and thoughtful approach to the argument. And I would say at the end, you really made our job difficult. You know, we've done this before, and we've done it with other judges, sometimes as many as 5. And a lot of times you'll have differing views between the judges. And I didn't expect that to be the case with just 2 of us. I'm often inclined to agree with Judge Alloy, and I think the same could be said of him, but you all really presented a razor-close end to this competition for which you've worked so hard. But at the end of the day, again, by just the slimmest and narrowest of margins possible, we did believe that counsel representing Blue Sky prevailed in this particular one. So congratulations. Well done.
Okay, congratulations. Do we? present something? Yes, thank you. And I too, very